morning, everyone. This is the Town Hempstead Board of Appeals, August 30th, 2016, 9:30 a.m. public hearing calendar. Everyone please rise for the Pledge of Allegiance. Hands over your heart. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Everyone please have a seat. There is one case on this morning's public hearing calendar, and I believe there is an adjournment request. Mr. Chairman, cases 1424 to 1429 of 16, Green 2009 Inc., 3500 Sunrise Highway, Montauk. Whoever has a request for an adjournment, will you please come forward.
Reggie Carolla, 775 Walter Avenue, Montauk, New York. Good morning, Mr. Chairman, members of the board. I'm here with a number of community residents. I assure you the room will be packed. However, we let the word out that I had spoken to Mr. Aberdeen, and by mutual consent, that it's our application, that we would respectfully request an adjournment of this matter. Quite obviously, the end of summer, you're getting calls, what is going on here? What are they trying to sneak in? So it's one thing to get a bad decision, but obviously better to get a good decision. But it's another thing when government doesn't look transparent, and when moms get their children ready for schools, the PTAs have been very active in this matter, and the community really didn't know anything about this until 2 weeks ago. And so therefore, based upon these and other reasons, we would respectfully request an adjournment in order for the community to prepare its response. Mr. Aberdeen?
Yes, just to correct Mr. Grove's statement.
Mr. Aberdeen, if you would, I'm sorry.
Appearing for the applicant, Howard Aberdeen, 575 Underhill Boulevard, Syosset. I did speak with Mr. Grove by telephone, but I just want to make it crystal clear for the record that the applicant did not consent and does not consent to the adjournment. The applicant does understand the board's normal procedure as far as adjournment request is concerned. A letter was sent to the board reflecting the applicant's position as well as suggesting some proposed dates that might work in the event the board was inclined to grant it. But we were ready to go.
Understood. Mr. Rhodes? And I didn't mean to intimate that that was the contrary.
Okay.
Thank you, Mr. Chairman. Stephen Rhodes, I'm the County Legislator for the 19th Legislative District, 2234 Brody Lane, Belmore, New York, 11710. Joining in the application that's made by former State Assemblyman, former Controller Fred Carolla, my office has been in contact with dozens of residents who represent probably hundreds of residents, if not more, who are concerned about the application, concerned about the fact that they were receiving late notice, and want the opportunity to be able to research and be able to present the case in opposition to the application. Obviously, they need time in order to be able to do that, but more importantly, we want to make sure that we don't have the perception that something was being rushed through at an inopportune time for the residents to be able to be fully informed and be given an opportunity to voice their opinion. So, again, I was joining the application that's made by someone in Rule.
Is there anybody else that wants to be heard on the application?
I just want to make one statement
Yes.
regarding Legislator Rhodes' statement. He used the word late notice. I presume he meant maybe something inconvenient or whatever, but notice was not late. Notice was, all notice requirements were filed meticulously, followed meticulously in this case. So I just want to thank you.
And just for the record, as most of you probably know, hopefully, this is under the, I guess under the auspices of a federal court directive that this case is going to move forward, which is why it was given the original date that it was given, which did follow all the normal procedures. But as is our normal practice when a case is on for the first time, if somebody requests an adjournment, we would normally grant that because we want to give everybody an opportunity to at least prepare if they have opposition, to prepare opposition or in favor either way. So that is why it's on here and it's marked for an adjournment as a request was made. Mr. Ricacci, you wanted to say something?
Yes.
Name and address on the record, please.
Can I sit down, please?
Yeah.
Felix Ricacci, 1165 Bond Street, Franklin Square, New York. I'm neither here to oppose this or to affirm this application, but I do oppose any adjournment based on the history of this case. The case went on, was decided 5 years ago, 2011, November the decision came up, and the decision was in complete agreement with everybody, not decided on its merits. There's the hearing, which I read the transcript, I have them here, I read extensively, hours of testimony by all the residents. Essentially, the case boils down to the lack of credibility of Billy Dean, and that was determined by the town and everything not to be a valid reason on the merits.
Mr. Patachi, we have a brand-new application before us.
Sure,
And we have to deal with it as a new application.
of course, and as a new application, the reason that it's summertime, I don't believe is a valid reason. It's given by the people who want the adjournment. It's not a valid reason because this case has been around for a long time. Essentially, residents did have an opportunity to object. Unless they could give a specific thing with the new application, do they object to the portico, which is a valid reason? Do they object to a particular aspect of the new
We
application?
are dealing with a request for an adjournment so that they can put together their opposition, not to detail what their opposition is today. This is the first time this new case is on. Our policy is when the case is on for the first time, we will normally grant an adjournment. I know that the parties have been in discussion, or there was some contact back and forth about the fact that there was going to be a request for an adjournment, and we're going to adjourn the case today to give them the opportunity to put together
So
their opposition. The applicant is not prepared to proceed. He knew that there was going to be a request today, so he did not pay his witnesses to appear today or be here today to give testimony. We're going to adjourn it to a date that is going to be a date certain, and then we are going to hear this case.
So details of adjournment are not required by this board to, you don't need to give any reason for your adjournment, just say, I want an adjournment, and that's good enough for you.
Just so you're aware, the date that I think is going to end up being chosen is one that's been proposed by the applicant, if I
Okay.
understand.
But again, they're requesting the adjournment so that they can put together their opposition. And this date has only been established, today's date was only established, I think, about 3 weeks ago, or maybe 4 weeks ago. Mr. Regina, do you? Okay, so it hasn't been terribly long that this date became the established date.
Yeah, but the thing, I understand that, but in reading all the testimony that was given by the residents, the opinion essentially,
You're hearing the merits of the case, and that is not what we're here to discuss. We're hearing the merit, we're discussing merits of the case that was previously heard. This is an entirely new application.
okay, so I just asked then that at the new hearing that's going to be had, that what was said here that was determined already by everyone not to be meritorious, not to be heard again, not to rehash everything that's been said since it's really already been determined by everybody,
It is a
not to be the merits of the case.
case.
And actually, the legal conclusions you're stating are not correct.
If they choose to make that part of the record, that is their prerogative. If the opposition chooses to make that part of the record, that is their prerogative. It is not our position to present evidence. It's our position to decide based upon what's presented.
I just have one more question for the board. Can this board indefinitely judge cases not on the merits, so this applicant is in perpetuity going before this board indefinitely? So,
I'm not sure I understand what
well,
you're saying.
you decided not on the merits the last time, so can you do it again and again and again and again, so this applicant is constantly paying legal fees indefinitely into the future, so he never gets a chance to open his, can you do that? Do you have the power to indefinitely put him in limbo?
Sir, your question presupposes a legal conclusion that we judge the case not on its merits. So the
That
whole
was decided by
Excuse me,
town.
you can only take one at a time. So your whole question is based on a fallacious presumption, a fallacious legal conclusion. So the fact of the matter is, as the chairman has said, we have before us a new case. And there's been a request made for an adjournment. He's explained why the board is going to be granted. We've received proposed dates from the applicant, and one of those dates, I am certain, will be that which is selected, so that we're trying to make the process as fair as possible for all involved.
Those conclusions that I'm drawing were decided by Peter Sullivan, the attorney for the town.
No,
It was decided.
Actually, we prevailed.
No, that's not what he said. It wasn't decided on the merits.
Mr.
That's what he
Procacci,
said.
we have a case that is going to be presented to us, and we will make a decision.
Thank you very much.
All right, based on, I understand.
Mr. Chairman, I was one other person left.
Okay, name and address, please.
I appreciate that, Your Honor.
I wish I could say I was the Your Honor, but I'm not. I'm just the chairman.
You deserve to be. It's Erica Dubno of Farragut and Dubno. I'm sorry. Erica Dubno of Farragut and Dubno, 767 3rd Avenue, New York, New York 10017. Good morning. I represent the applicants in the federal lawsuit that you referenced earlier there. The action is currently pending against the town of Hempstead and others in the United States District Court for the Eastern District of New York. I conferred with outside counsel Peter Sullivan, who's sitting in the back over here, before I gave testimony here today. And the reason is, while the BZA is not a party to the action, each of the individual members of the BZA were named in the lawsuit, and the judge found that the lawsuit is still pending. As part of the litigation on July 20th, 2016, District Judge Margot Brody held that the court still has jurisdiction over all of the named defendants. Judge Brody cautioned the parties, quote, "We are not asking that you somehow tell the board what to do or tell the parties how to act, but to make the parties understand that there is a pending court action, that their activities are under review, and that they need to act in accordance with their laws, but to do it promptly." Judge Brody continued that the plaintiff should not have to wait years for a decision. She further urged that the defendants try to move the process forward so that we can get it resolved. I have copies of the transcript from Judge Brody, and I've made multiple copies. I can give them up to Mr. Regina right now so that you have them and ask them to put it in the record.
There is no, the case is not open right now. I mean, this is a request for adjournment. So I don't know if you want to reference that or tell us why you're presenting that, but we're not accepting evidence right now because it's an adjournment request.
That's fine. It was just for information.
That we're not going to accept that.
Okay. We also recognize that the board, as a matter of course, typically grants one adjournment and when it is requested by a party or someone with an interest in the proceeding, and we appreciate that the board is doing it today. When considering the pending request for an adjournment and whether the board will grant a specific date, we ask that the board be mindful of section 272.1 of the Building Zone Ordinance. That provision, which was recently enacted to address the very litigation that is pending before Judge Brody, provides in pertinent part that any application which the applicant asserts to impact constitutionally protected freedom of expression shall have a preference over all other cases before the Board of Appeals in its review and scheduling of a public hearing. The preference provision further provides that the Board of Appeals shall render its decision on a completed application in no more than 15 days after the hearing record is closed, or at the next hearing, whichever time is shorter. We want to reaffirm that the application to operate a cabaret, which will feature information as protected by the First Amendment and Article 1, Section 8 of the New York Constitution, impacts constitutionally protected freedom of expression, and as such, the applicants are entitled to a preference under Section 272.1. There are just two issues I want to address in preparation for the upcoming, which I recognize the hearing has been adjourned or will be adjourned, just to prepare for it so that everyone's on the same page. The Board of Appeals is supposed to be autonomous. However, throughout the prior proceedings, the lines between the town and the Board of Appeals were substantially blurred. For instance, back in 2011, Charles Covitt, the deputy town attorney, conducted the rehearing before the Board of Appeals that caused the owners of 3500 Sunrise Highway to lose their cabaret permit. Moreover, the town's outside counsel, Peter Sullivan, and Mr. Covet actually drafted the Board of Appeals findings of fact for the rehearing proceedings. To ensure that the board's decision is truly autonomous, we ask that the town and its agents not interfere with or otherwise obstruct the upcoming proceedings before the Board of Appeals. For instance, the town attorney's office, including town attorney Raw, deputy attorney Charles Covet, and outside counsel Peter Sullivan, or other representatives from his firm, should not be involved in the public hearing to be conducted by the Board of Appeals and the board's decision-making process. If the notion of autonomy is to have any meaning, then the town and its attorneys should not be ghostwriting the Board of Appeals. The town, I will give it to you after. The town and its attorneys should not be ghostwriting the Board of Appeals findings and/or moderating the hearing, which is precisely what happened when the appellant's cabaret permit was taken away back in 2011. Furthermore, to avoid the hearing from becoming unduly influenced by legislators or other political representatives, we ask that the hearing follow the typical procedures set forth in the Board of Appeals rules. Specifically, pursuant to Article 3, Section 3 of the board's rules, the applicants should present their direct case before objectors or other interested parties shall present their case. I point this out because during the rehearing in 2011, then Supervisor Kate Murray and others were allowed to speak against the application before the applicants ever had an opportunity to present their case. We believe that this substantially prejudiced the applicants, and we do not believe that such extraordinary relief is warranted in this case. We appreciate the board's consideration in this regard. Thank you.
I'm not going to completely respond to what you just read. I mean, we will take your request under advisement. I will say one thing, that at the rehearing, when the applicant's case, when the decision was revoked, Mr. Coleman did not chair that meeting. Mr. Coleman sat in on the meeting as on board as our acting attorney that day, but he did not chair that meeting. In any event, I was given a request by the objectors for a long adjournment, which obviously we cannot do. We did have correspondence from Mr. Abertine that gave us a couple of options for dates, and we tried to fit when that fit into what would be a logical progression, or at least some. We went through the dates that were given to us as possibilities. And trying to accommodate everybody's wishes, we had, I think the logical date for us to choose would be October 13th at 9:30 a.m. I think that was, it was, I think, the following week after, it was one of the dates that you had given us. And it takes us into a period of time so we can get everybody back from summer vacations or whatever. This hearing will take place on that date. It's not going to be adjourned again. So everybody's going to be coming in prepared on that date. And we will go, we will start at 9:30 in the morning, and we're going to go until we finish. All right? So that's October 13th at 9:30 a.m.
Thank you very much for your
Just for the applicant will be required to take the sign postings.
Yes.
3 weeks prior to the new adjournment date. Mr. Abertine, I will email you the new sign posting affidavit. Folks in the audience, so you know, there will not be a further mailing notice unless something in the variance requests were to change. That would only be triggered by the applicant filing a supplement or an amendment in the buildings department. And there will not be any further publication notice of the hearing. Okay? If anyone forgets the date and time, call the office.
What is the date again?
October 13th at 9:30 a.m. and that is a Thursday. It is a Thursday, not a Wednesday. It's a special date we're setting aside just for this case.
Thank you.
All right, thank you all for your patience, and we will get this resolved. Yeah, what's the adjournment?
Folks, there's a sign sheet still going around. Sign it.
I know it's going to get interrupted. Says Billy says, "Oh, I never heard anyone get interrupted at Board of Appeals." You think you're going to let me? Thank you.
Well, you know, shows what marina course.
I had a whole thing, prepared. I was been working on it. Changes 12 hours. Vision it's ridiculous. Yes, sir. They're going to come back. What are they going to do? Adjourn on what? There's two issues that are discussed. Portico and trust. Let's discuss that. Yeah. How much you going to spot? It's a portico. I don't like the portico. I don't think the portico is 100 people bumping into it. Okay. That's one argument. And traffic. What additional cars are going to send us highways over a period of hours is going to be traffic. So those two things, all they're going to do, like the whole hearing, I read I should put how much was adult entertainment. It was the whole thing. And then it was determined to be on the merits. So they're going to have a whole nother hearing that they're asking about. Fortunately, I have 64 chips on it. So I could go 16 hours.
So you have a camera on the witness and on the...
Yeah, I have two because sometimes one does go out. Sometimes things happen. So you get the sound and everything. Well, they get away with it. Like I said, I put interested in it, and I never take a position on it. They just watch my videos. I never say for or against it. Once in a while, eventually it's a violation of the law. Usually, it's only just I say an opinion. I never really take it. Yes. No. I don't know. I don't know if they're going. I haven't heard. I can't ask it because she attorney-client privilege as an last attorney. He was supposed to sue. He told me he was supposed to do it, but I don't have because it's expensive. I can't, so I can only help people who are willing to stuff. Like I said, I'm just the facts media. That's all I am. I waste no opinions. My own opinions on Facebook, usually with a lot of eating stores. But I don't really, he does it himself. He really sticks up more. Yeah, well, essentially they are. I mean, I had a whole thing talking about the windows of the restaurant. That whole thing there was collusion. I had questions asking me to collude with the town council. What out is the reason for the windows of the restaurant was to prevent a cabaret opening up as a restaurant in Guys. It turned out to be based on a law that, based on an event that happened 35 years ago, prior Hempstead dining.
So 4 of us.
Okay.
Listen,